afternoon. Thanks for joining us today. I'm Mark Hirsch, a non-attorney spokesman working with Polatsek, Boheme, and Wilkowski, and I'll be moderating today's discussion. Before getting underway, today's discussion is for informational purposes only and does not constitute legal advice. I'm joined today by Serge Boheme, partner at Polatsek, Boheme, and Wilkowski. Serge advises employers nationwide on business immigration matters, including PERM strategy, compliance, and long-term workforce planning. He works closely with HR teams, in-house counsel, and leadership to navigate both ongoing sponsorship needs and broader policy shifts. Serge, we've gathered questions from employers and HR professionals who are navigating PERM for the first time or dealing with it right now. Your firm maintains over 99% PERM approval rating. That's not a number that happens by accident. So let's start at the beginning. What does your intake process look like that most firms skip or shortcut?
The intake process is where most PERM cases are either set up for success or quietly compromised. What we do differently is we treat intake as a substantive legal phase, not an administrative one. We conduct a deep, structured analysis of the role before anything is drafted. That includes aligning the job description with business realities of what the company needs, business necessity, reviewing internal hiring history, evaluating minimum requirements against DOL norms, and stress testing whether those requirements will withstand scrutiny. We also interview all the relevant stakeholders. HR doesn't always know exactly what the hiring manager or the person who reached out to us to see if we could sponsor an employee. And we need to get to the inconsistencies that are happening over there. We want to go with what the employer really wants and translate it into a description that withstands legal scrutiny. Many firms rely too heavily on templated questionnaires. We don't. We build a factual record early, anticipate vulnerabilities, and document rationale contemporaneously. That's what allows us to move confidently later, even years down the line if the case is audited.
And audits are one variable that no employer wants to face, surely, but they do happen. So when the Department of Labor selects one of your cases for audit, how does your response process differ from what you'd expect out of a less prepared firm?
An audit is not where you start preparing. It's where your preparation is revealed. Because we build a complete evidentiary file at the outset, an audit response for us is largely an exercise in organizing and presenting, not scrambling or recreating. Every recruitment step, every business necessity argument, every communication is already documented with audit readiness in mind. Where less prepared firms often react defensively, we respond deliberately. We treat the audit as an opportunity to demonstrate compliance clearly and confidently. Our responses are structured, indexed, and written with the assumption that a human adjudicator, not just a checklist, is reviewing the file.
And so priority date backlogs, agency workloads, shifting policy, sometimes an employer has done everything right, and they're still looking at a decade-long wait for an employee from India or China. How do you counsel them through that?
Well, this is where legal strategy intersects with human reality. We start by reframing expectations. PERM approval is not the finish line. It's one step in a longer immigration life cycle. For employees from heavily backlogged countries, we focus on optionality. Can we upgrade to an EB1? Is there a path to an NIW case? Should we preserve flexibility through job structuring or geographic consideration? We also advise employers on retention strategy. When someone is facing a 10-plus year wait, immigration becomes a key component of employee engagement and stability. Transparency, planning, and periodic reassessment are critical. Most importantly, we acknowledge the uncertainty. You can't eliminate it, but you can manage it with foresight and alternatives.
Serge, what's the employer behavior, not the attorney's behavior, that most often puts a strong case at risk? And what do you find yourself correcting most?
Well, I'd have to say inconsistency. It's usually unintentional. The most common issue we see is a disconnect between how a role is described internally, how it's advertised externally, and how it's ultimately presented to the Department of Labor. Even small deviations, different requirements, vague duties, inflated qualifications can raise red flags. We also see employers underestimate the importance of documentation discipline. Recruitment steps are sometimes treated as procedural checkboxes rather than legally significant events. What we consistently correct is the mindset. PERM is not just a hiring exercise. It's a regulated process with evidentiary standards. Precision does matter.
So I know it doesn't happen often in your firm, but can you walk me through a denial? What's the first conversation that you have with the employer, and what are some of the realistic paths forward?
Well, the risk of this sounding self-serving, and I don't have much experience with that, but yes, our firm has had to deal with a couple here and there. The first conversation is about clarity. It's not about blame. We walk the employer through exactly why the denial occurred, whether it's a recruitment issue, a prevailing wage misalignment, or a legal interpretation by the officer. Then we assess options. Is it a motion to reconsider, an appeal, or a refiling? In many cases, actually, I'd say most. Refiling, if done correctly, is the most efficient path, but that depends on the facts. When the employee has been waiting for years, the tone of the conversation changes. There's more at stake emotionally and professionally. We address not just the legal strategy, but the impact, priority date loss, visa timing, retention concerns. We're candid, but we're also solutions oriented. Even in a denial, there's usually a path forward. It just needs to be navigated carefully.
And if you could change one thing about how perm cases are generally handled across the industry, not the law, but the practice itself, what would that be?
I would eliminate the over-reliance on templates and assumptions. PERM is highly fact-specific, yet too often it's approached as a volume process. That's where errors creep in: misaligned job descriptions, unsupported requirements, overlooked audit trigger. A more disciplined, case-specific approach at the front end would prevent the majority of issues we see later. It's not about working harder, it's about working more deliberately.
Last question I have for you, Serge. Behind the approval rate, there are real people whose lives hinge on the outcome. So, what keeps you motivated to maintain that standard case after case? And can you give us like a specific moment, not necessarily a case, but a moment that reminded you why this matters?
Well, I guess to answer your question, I'd have to go with two parts. One is personal of mine, just my way of approaching things. The other one is really a reflection of what our firm works like. The first one, I'd have to point out to the movie with Brad Pitt. It's where he is a baseball general manager.
Moneyball.
Moneyball, thank you. There's a part in it where he's describing the process and what the players need to do to get better at everything that they're doing. And he starts telling them, and that's how winning is done. I hate losing more than I like winning. There is a difference. He's absolutely right. I feel that, approvals, I very much enjoy them, but, once they pass, I forget about it. I go about the next case. But a denial, whew, that stays with me. So it's an aversion to have that talk. I hate a denial about 100 times more than what I like an approval. So personally, it's the drive to avoid those. Having said that, point in your career, you realize that behind every case, it's not just a process, it's a life trajectory. You remember a moment early on, not a dramatic case, just a quiet one, where an employee, after years of uncertainty, of waiting, dealing with many trials and tribulations, he received an approval. And he came by, gave me a big hug and said, now I can plan my life with my family. That stayed with me. These are real stakes. These people, they're depending on this. And the company was also thrilled because he was a key employee for them. It helped them succeed. It helped them, in ways that they just would not have been able to complete in the global market the way that they could with him. What we do creates stability where there was none. It allows families to put down roots, to make long-term decisions, to feel secure. That's what sustains the standard, not the approval rate, but what it represents.
Wow. Well, Serge, that's genuinely an eye-opening revelation that you've just shared. So, for employers and HR teams who want to learn more or start a conversation with your firm, where should they go?
Well, we have a website, polatsek.law. Just go in there and you can click. There's a button in there where I believe you can request for a free consultation. The initial consultation will be for free. We'll be more than glad to, for your situation, let you know what options there are and take it from there.
Wonderful. Well, Serge, thanks so much for your time today.
You too, Mark. Great to see you again.